Welcome to the second installment of our Special Asset Summer School Series. Sorry, of our Special Asset Summer School Series. We are super excited that you're here. This class is led by Norman Leonard and Jameson Dow, and they are exploring first brands and first days in Chapter 11. I'm Haley Cook, the marketing coordinator of events here at Ward & Smith, and I'll be your moderator this afternoon. Just get to my housekeeping slide. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature, and I'll be sure to troubleshoot with you. This webinar is being recorded, and I'll send you the recording probably tomorrow morning. And then you can always check out our website for past webinars. So if you missed last week or if you missed last month's, or you want to send this to a friend, please do. Like I said, I will send you the recording, but also you can access those on our website through the webinars link, which is right on our homepage. Our speakers are happy to take questions during this webinar. If you have any questions, you can type them in the Q&A box, and it will be addressed at the conclusion of the presentation. As I mentioned, our speakers today are Norman and Jameson. Jameson is an attorney in our Greenville office, and he is focused on bankruptcy and creditors' rights, helping banks, lenders, and other creditors through collections and bankruptcy proceedings. He recently clerked for Judge Joseph Calloway on the U.S. Bankruptcy Court for the Eastern District of North Carolina, and now handles everything from commercial loans and foreclosures to restructuring and workout documents. Norman is in our Asheville office and represents lenders, manufacturers, and other creditors in bankruptcy and workouts, while also helping businesses protect their trademarks from clearance to registration to proceedings before the USPTO. So, sorry, there they are. So I will go ahead and turn this over to Jameson or Norman. I'm not sure which one of you wants the mic, figuratively speaking. Norman, I'll toss it over to you, Norman.
All right, thank you very much, Haley. Good afternoon. Again, as Haley said, my name is Norman Leonard, and I'm practicing our firm's Asheville office. I've been here for almost 16 years. And with that, we'll get started. Okay, so for the agenda for today, we're going to discuss some things that can happen in the first hours and days of a Chapter 11 bankruptcy case, particularly first day motions, and with a particular focus on motions to use cash collateral that the debtor might file. And we're going to discuss why secured creditors should be prepared to act immediately when a bankruptcy is filed. And we're going to also discuss a real-world example of the case of First Brands Group, which shows how a creditor should defend their rights when faced with a motion that would negatively impact their rights and their collateral. Before we move on, I just want to say that while we're going to cover some basic legal concepts in these areas of bankruptcy law, we just want to emphasize that this program is only a high-level review of those concepts and is not intended to be legal advice. Every factual scenario is different, so please consult with your legal counsel if and when you are confronted with any similar bankruptcy issues. All right, next slide, please. Okay, so let's begin with so-called first day motions. What are they generally? Well, when a company files Chapter 11 bankruptcy, it's typically doing so to get some breathing space from its creditors, and it wants to either reorganize its financial affairs or seek a path to the orderly liquidation of its assets. But of course, the bankruptcy filing is a hugely significant event that can create a long list of additional problems for the company besides just its creditors. And to ease the transition of the company into bankruptcy, the company is usually prepared to immediately file various motions on the first day of the bankruptcy case or shortly thereafter. And these so-called first day motions seek to address various administrative and operational issues that the debtor is likely going to face as a result of their bankruptcy filing. On the administrative side of things, these motions might cover issues related to general administration of the case, such as extensions of time to file certain documents, motions to establish procedures for future hearings in the case, for telephonic appearances, for how notice will be provided to creditors, and the other mundane details of administrative bankruptcy. But administrative motions might also include motions to jointly administer multiple bankruptcy filings by a group of related companies so that all the bankruptcies will be joined together in a single administrative case. So administrative motions, first day motions can really run the gamut. On the operational side, first day motions might address issues related to the debtor's business, that might allow the debtor to take actions to continue operating its business that it might not otherwise be able to take without court permission. One significant example of an operational first day motion is a motion to seek an exception to the imposition of the automatic stay. I'm sure most folks on this call are familiar with the concept of the automatic stay. Basically, when a debtor files for bankruptcy, the bankruptcy code imposes the automatic stay, which is an injunction on nearly all actions by creditors against the debtor or the debtor's property. And first day motions can create exceptions to this rule to allow the debtor to pay certain pre-petition debts that would otherwise be a violation of the stay by the parties receiving those payments. And these sorts of motions are intended to maintain the debtor's existing relationships with creditors, with critical suppliers, and with employees and that sort of thing. And these first day motions may seek relief on an interim basis or on a final basis, depending on the type of relief that is being sought. So the objectives of first day motions are fairly straightforward. They seek to ensure the minimal disruption of the debtor's operations. They help the debtor maintain its critical business relationships. They're meant to preserve the value of the debtor's assets for the creditors and other stakeholders in the company. And they're meant to establish an administrative framework for the Chapter 11 case going forward. Next slide. So when considering first day motions, courts will distinguish between matters that require emergency relief and those matters that are merely deserve some form of expedited relief. Where the requested relief is more substantive rather than merely procedural, meaning that it could negatively impact or prejudice third parties, then that relief should be limited to matters that are genuinely necessary to maintain the debtor's business and preserve its assets. And courts are going to balance the debtor's interests as a going concern with the rights of creditors and other stakeholders to make sure that that fairness is accomplished. And for these reasons, some first day motions may be granted with little to or no notice to creditors or other third parties, and some first day motions will require additional notice. Next slide. Okay, so boiling these concepts down to some general rules, debtors' first day motions on administrative matters, such as those concerning the structure and procedures of the bankruptcy case, may be granted on a final basis without any notice to third parties. And for motions that are truly administrative in nature, then this is usually isn't such a big deal for creditors. But in contrast, first day motions on more substantive matters, which may impact the rights of third parties, may be granted on an interim basis on fairly short notice, with hearings on whether to make that relief more permanent scheduled for a later date. When first day motions do touch on substantive matters, the debtor will typically be required to provide notice of the motion to at least its 20 largest unsecured creditors, which are usually those creditors who are going to form the basis of an unsecured creditors committee in large bankruptcies, and then also to provide notice to any secured creditors whose collateral interests might be implicated by the first day motion in question. Okay, with that, I will turn it over to Jameson to discuss how creditors should review first day motion.
Thank you, Norm. Well, good afternoon, everyone. Just as a brief additional introduction, I'm Jameson Dow. I do creditors' rights and bankruptcy in Greenville in our firm's Greenville office, and I've been practicing with Warden Smith for almost 3 years at this point. Norman did a really good job of kind of going over what we expect to discuss today and a high-level overview of the debtor's first day motions that are, at the forefront of the creditor's mind when they get that notice used to be in the mail, now, probably over email, but a notice of a bankruptcy filing, which always, puts some fear into you. So yeah, getting into kind of the considerations that creditors want to consider when a bankruptcy is filed and the first day motions that debtors are bringing before the court. Um, these motions can often provide a lot of insight and transparency into the debtor's business, both historically as well as where they project and see themselves going forward throughout the case. So you'll get through these various motions, pleadings with the court, you'll get a view into the debtor's case, what they expect. You'll get an introduction to who this debtor is, what their business looks like, to the extent creditors aren't too familiar with it. It's a very bankruptcy is always a very transparent process, and so nothing is meant to be under seal, under the cloak. It's supposed to be wide open, and as far as creditors are concerned, wide open into the transactions and financial information of the debtors. You also get an understanding of what led to the bankruptcy filing. And we'll talk about that more, but that's important because a debtor may have a very different idea of what led to the bankruptcy filing from what the creditor may pose. And we'll talk about examples later, but there can be conflicting or contrasting views of what led to it. And then finally, like I said, you'll get insight into the debtor's business and operations historically and what they expect going forward. So when creditors are evaluating a debtor's recent bankruptcy filing, a lot of considerations should be kept in mind for the creditor and the creditor's attorney, which will be important based on how the case unfolds. Those first day motions are kind of the introduction to the debtor into the bankruptcy case, and oftentimes how that is kind of like first impressions. How those first motions go will oftentimes impact potentially whether the case will be successful going forward or not. So first, we'll find out why the debtor filed and its plans for emerging from the Chapter 11. Keep in mind that bankruptcy cases can adjust very significantly from a debtor's original plan, meaning, sometimes the debtor may have filed with the full intention of a successful reorganization, cutting some of the fat out of its business and becoming lean and moving forward as a reorganized debtor. But sometimes that's not what happens. Sometimes it, for whatever reason, maybe fraud is uncovered, case is dismissed, converted to Chapter 7, ends up in liquidation, or maybe, the debtor they tried to give it a second chance through the bankruptcy filing, but things didn't work out, end up having to liquidate. And then, also, it's not always bad news. Potentially, they could, find other creative pathways for finding a successful reorganization. And then, kind of as I discussed before, so the debtor is going to put before the court in its motions in the first day hearings what led to the bankruptcy, why we are where we are. And sometimes, not to say that those would be false, but sometimes they just need further supplementation or explanation from the creditor's perspective. A good example would be a single asset real estate debtor, which is essentially where the debtor just owns, one piece of property, and that property brings funding into the debtor and uses that to pay creditors. The debtor may contend that, this is just a simple matter of failure to keep tenants in the building, failure to collect rent, went on some hard times. It's become difficult to keep the business going, but things are looking up. And that's what led to the bankruptcy, and that's what they're going to put in their pleadings and represent to the court. But from the creditor's perspective, there may be a lot to add to that. And so creditors, kind of the main theme of today's presentation is creditors want to act quickly, want to act promptly in telling the whole story and protecting their rights. In this example, potentially there have been many months beforehand of forbearance modification discussions that ultimately ended up falling through, leading to litigation, commencing foreclosure proceedings, things of that nature. Creditor underwent extensive title work, attended court hearings, and then all before the night the night before the foreclosure sale, debtor files bankruptcy, stops everything on its head through the automatic stay Norman was talking about. So that's something we would want to show the court that would add additional detail, add additional color to why we are here and what paths have already been already gone through during the case. Additionally, obviously, the considerations are to protect the creditor's rights in the bankruptcy, especially when, those first day motions, not so much the administrative ones that Norman was talking about, but some of the more substantive ones may directly impact creditors' rights. It's very important to, review those motions, review the relief that the debtor is requesting, and act promptly in order to preserve the creditor's rights, protect their interests, and if creditors do not do that, those rights will probably be waived, and or you'll be shoving a square into a circle hole. You'll be forced into uncomfortable treatment that you're not okay with. And then finally, or another consideration is assessing the risks of continuing to do business with the debtor. So some vendors may need to make this consideration if they're going to continue providing goods, providing services to the debtor on an ongoing basis, or whether it makes more sense to take the claim you have as of the petition date and just seek recovery. That's definitely a consideration, and that'll be based on the historical payment history, certainly, but just the business relationship with the debtor, and whether or not after a bankruptcy is filed, business wants to keep going. Going back to our example of filing a petition the night before the foreclosure sale, that could maybe you don't want to do continued business with that debtor. And then finally, you can assess whether and how the creditor is going to be paid on their existing and future claims against the debtor, i.e., in other words, we're looking at kind of the outset of the case. Is it likely to succeed under a reorganization? So those are kind of the key considerations that I view when a debtor files bankruptcy. And Haley, if we could shift to the next slide, as Norman kind of forecasted, there are several different first day motions that we could see that a debtor will file in order to keep their case moving forward, and the creditors are going to want to review and make sure that their interests are not being undermined or impacted negatively. So we'll start, and you see on the slide, these are kind of the high level ones that we usually see, or oftentimes we'll see when a new debtor files bankruptcy, either with the petition or in the very first few days after it's filed. So beginning are some of the employee and wage benefit kind of motions. So debtors oftentimes, after they file bankruptcy, will seek authority to pay pre-petition wages, salaries, benefits, withholdings, whatever it is, for their employees. And the reason this is important is because, as Norman mentioned, that automatic stay, this is one of those examples of an exception to it, to pay claims that were pre-petition that otherwise would not be allowed to be paid under the bankruptcy. But there's, an obvious reason for why debtors would want to do this, and pay those wages that were incurred before the petition was filed for their employees of the business. Obviously it maintains employee morale, and more importantly, it prevents, departures of the employees from the business to go to, another business. And so, that's a very important consideration. And also, for the debtor, this is also important for the debtor to continue as a going concern, right? So if the debtor loses all of its employees, then it's going to have a difficult time reorganizing under Chapter 11. And from the creditor's perspective, potentially if this is using creditor's cash collateral in order to pay those employees, it's not always, a bad thing from the creditor's side, because potentially the best chance for recovery is for the debtor to continue doing business, to continue getting income into the business, as opposed to, just calling it a day and liquidating everything. There is a consideration that under the bankruptcy code, there's a cap to some of these claims. It's $10,000 a claimant. So that's just important in the sense that, we want to keep the employees happy, but there's a limit to everything. And very likely, oftentimes these come up practically on a 2-week basis. And so, usually employees have not accrued that much to hit the limit. These claims are treated differently from other pre-petition claims due to the importance of the debtor continuing as an ongoing business. For example, a bank that's owed money under a loan is going to be treated differently from, a debtor's employee that's a mechanic and is necessary to keep the business going. And so kind of like practically speaking, how this comes up is, say there's business X that pays employees every Friday. Bankruptcy is filed on a Thursday. They've already performed those services prior to Friday and cannot get paid because those are technically pre-petition claims. So the debtor under the bankruptcy code, because of the automatic stay, et cetera, has to go before the court and seek court authority in order to pay them. And as I discussed, it's oftentimes in everybody's best interest to get those employees paid to keep the business going. There are cash management motions that are often be filed with the first day motions. We'll get into more detail on cash collateral later and through our first brands example. But some of the common ones entail the debtor's ability to maintain existing bank accounts, cash management systems. So oftentimes, I know there's a local rule in the Eastern District. I'm sure a lot of districts in North Carolina and across the U.S. Have similar rules. But because when a debtor files bankruptcy, a debtor's estate is opened, there's oftentimes a requirement that the pre-petition accounts be closed and what's called the debtor-in-possession, which is a Chapter 11 debtor, operating under the bankruptcy, creates a DIP account. Some of the financial lenders in this, attending this presentation may have dealt with DIP accounts before and opening them. But there are some reasons that, creditors would have. This seems like just an administrative task, but there are certain reasons that creditors would be very interested in this. One example in a case that we had is, the bank had very little or that did not have a lien on cash collateral, did not have a lien on the debtor's accounts. However, because the debtor filed with a significant amount of funds in the account, that created a set-off right. And so we immediately, wanted waiver of that local rule that would require the debtor to close that account and open a DIP account because, we'd lose our secured position. And so there are, even when it's an administrative task or seemingly administrative task, there's important considerations to make sure the bank is properly secured, and there aren't issues, or rights waived. Let's see, moving to utilities. Another focus of first day motions includes payment of utility services. This one kind of is similar with the pre-petition wages of employees. It obviously gets to the debtor's ability to continue as a business moving forward, which, as you might imagine, requires keeping the lights on and the water running. There must be, under these requirements, there must be, adequate assurance that payment will be made to the utility providers. They have a little bit of a stronger position and leverage under the bankruptcy code to ensure that they are paid. Which basically this provision is found in 366 of the code, prohibits utilities from denying service to the debtor based on non-payment before the petition was filed, if the debtor is able to provide adequate assurance that payment will be made post-petition. And these, again, very important in the sense of keeping employees happy, keeping the lights on, keeping the water running. It's all important in keeping the debtor's business going as a going concern. Critical vendors and essential suppliers are other motions. So these are authority to pay pre-petition claims of vendors that are critical to the debtor's ongoing concerns. This is similar again to paying employees, paying utilities, and it's grounded in the idea that without these otherwise improper payments, the debtor may fail. So it's paying pre-petition claims in order to keep the debtor operating. From a creditor's perspective, if the debtor fails, the creditor may suffer larger losses than it otherwise would, because again, the debtor operating as a going concern can, in some cases, be the best source of recovery in order to create income and pay off the debts. This can be controversial and burdensome, though, as far as critical vendors are concerned, because courts look at this with some scrutiny. There's something called the necessity doctrine in order for essential vendors, critical vendors to receive these pre-petition payments, and some courts are skeptical of these because essentially what the debtor has to show is that there's no replacement for this vendor. A finding that the vendor is so necessary to the debtor's reorganization that the debtor would fail without it. And in exchange for that, the payment of pre-petition claims, the vendor provides post-petition services. So this also gets back to what we were discussing about whether or not the creditor wants to continue business with the debtor going forward. So if you're a creditor seeking payment under this, avenue, and the debtor's moving to be able to pay these as pre-petition claims, there's kind of a collateral damage or a balance here that you're getting paid on these pre-petition claims, but you've got to keep providing these services on an ongoing basis. Additionally, joint administration. This can be mostly an administrative idea, but it can also seriously impact creditors' rights as well, and creditors' interests. Essentially, what these will do when it's purely the joint administration side, this is, essentially take two debtors that filed on the same day, related businesses. They're seeking for administrative efficiency, for noticing purposes, to consolidate certain issues in the case, like sending out notices to similar creditors, because these businesses kind of run parallel to one another. Although they're not substantively the same, they are two separate businesses. What these motions will often do is create a single docket, unified notices, but does not merge the two debtors' cases. It just cuts out some of the extra administrative expenses that may accrue and may become burdensome if the debtors completely operated differently and separately. And this is important because, a lot of Chapter 11 cases can become what's called administratively insolvent, where the administrative fees, which get priority claims, can become too burdensome. And it can cause a debtor to fail under that basis. So this creates an opportunity, when appropriate, to consolidate some of those administrative matters. But it's important from a creditor's perspective, because what we want to monitor, and this can be done through several of the other first day motions, especially cash collateral, is that there's not also a substantive consolidation where the debtors kind of run as one. For example, you don't want one debtor keeping the other debtor alive. So our example for this one is basically two debtors doing similar businesses, one roofing, one is selling solar panels. If one debtor is truly failing, heading for Chapter 7 liquidation, is not going to be able to create a successful reorganization, as a creditor's attorney, you want to be able to catch on to this quickly. And you want to avoid that administrative consolidation that may drag one down, while the other one could, be a profitable business that can reorganize. And the main consideration, again, acting quickly, acting promptly, is it can be very burdensome later on to try and unwind this after these consolidated debtors have, one's heading for liquidation, one is becoming successful. It's better to catch this at the outset and prevent it to the extent possible. Other common motions, retention of professionals. So debtors must move to hire their professionals. This would include their actual bankruptcy attorney, in the case, financial advisors, accountants, appraisers, any professionals fit that category. And so separate from paying employees under cash collateral, this is a different consideration because the court requires a motion and a hearing in order to employ these professionals. This requires, and creditors should keep in mind, a disinterestedness standard. Basically meaning, there can't be conflicts. You've got to make sure that the professionals do not hold or represent adverse interests in the estate that could create issues. And the debtor is required to seek court approval to hire these professionals. Creditors, from our perspective, we should monitor this closely, looking into this, making sure there's no conflicts, that they're disinterested, and also looking into what the debtor's proposing to pay as compensation, what service is going to be provided, the scope of that service, whether it's appropriate, because all of it is a balance of finding a debtor being able to reorganize, but being balanced with protecting creditors' interests. And then so those are kind of the main first day motions that we're talking about. And that's an overview of each of them. And then there are other ones that kind of touch on customer programs, whether they give gift cards, things of that nature. Oftentimes debtors, these bankruptcies can be rush filing sometimes, and so they'll file motions to extend time to file schedules, their statement of financial affairs, which again gets to the transparent process of the bankruptcy. But the bottom line in all these motions is we should thoroughly review them, we should read them, and we should make sure that whether they're administrative in nature or substantive in nature, they are not seriously impacting or negatively affecting the creditor's rights. And we can go to the next slide, Haley. So here we have a hypothetical. And Norm, if you wouldn't mind setting us up here, I can go through it.
Sure. Okay, so we have, do you want me to go through the facts first?
Yes, please.
Okay. All right. So here we have Prestige Furnishings LLC. It's a Chapter 11 debtor in possession seeking authority to continue paying its founder and CEO, Marcus Vance, an $850,000 per year salary plus a $15,000 monthly car allowance and free use of a company condo. Nice if you can get it. Ironclad Capital Bank, the sole secured lender, and first priority lien has a first priority lien on all cash, receivables, and inventory, is objecting to the motion, noting that comparable executives earn $250,000 to $325,000 per year, and that payments would be using as cash collateral to fund an insider giveaway. So the question is, with no cash collateral order or adequate protection stipulation in place, can the court authorize Vance's full compensation package over Ironclad's objection? And if not, what framework applies and what is the likely outcome in the situation? James.
Thank you, Norm. First, let me comment on what a good gig that is. Wow. I would like that gig. But the answer is absolutely not. So as we've discussed, bankruptcy, and as everyone knows, bankruptcy is a transparent process, and it's an opportunity for the debtor to find a fresh start. And paying out, a number of that size when, there's really no logical basis to support it, in addition to the car allowance and free, residence at a company condo, doesn't really make much sense and isn't necessary for the debtor to reorganize. It's also in the cash collateral, certainly something you would, as a primary secured lender, not what you would want to consent to for the cash collateral to be used for that purpose. But yes, so there are two kind of independent bases for objecting here. The first is, as we mentioned, in this example, Ironclad Capital Bank is the primary first position secured lender. And the court and the debtor cannot allow use of that cash collateral without there either being consent or the court finding that the creditor is adequately protected. And so the debtor's got to file a motion, got to request relief. And in this example, the relief that they've requested for those figures do not make sense. Additionally, an issue in this one is that this is an insider transfer. And so there are other protections, and this kind of gets back to the idea of the disinterestedness and conflicts is, clearly this is probably the one making decisions here is this Marcus Vance guy, and he should not be allowed to get these payments, these large payments to himself, that as an insider. So that's another basis for objection, and it goes without saying. And of course, this is kind of an absurd example, but it just kind of shows how clear on its face it is of the inequitable nature and the debtor's proposal here. Obviously, in the real world, and this example could have happened to some extent, but in the real world, we just want to be mindful of, what the debtor is proposing and kind of read in between the lines, and make sure that everything is above board, everything is transparent. And so the likely outcome here would be, as it should be, the court is going to deny this motion on this requested relief and not have those payments made. But Ironclad would have the opportunity to, negotiate, find a consensual basis, or the court is going to require the debtor to provide adequate protection. And later we're going to talk about a bit about what adequate protection looks like when we're talking about cash collateral. All right, and we can move to the next slide here, Haley. And I'll pass the torch back over to Norman.
Thanks, Jameson. All right, so we're going to take a quick look at a fairly recent decision in an ongoing bankruptcy case called First Brands Group, which some of you may have read about in the news because it was a very large company that had owed a lot of private lenders money, and it caused a big scare in the private credit markets about exactly how soft and overheated, depending on how you look at it, those markets were. But it provides the specific decision within the case that we're going to look at provides a good example of how a creditor can act quickly to protect their interests when faced with a motion that was going to be clearly prejudicial to their interests. So the First Brands case involved a group of related companies that were in the business of selling aftermarket auto parts. They all came together, filed their individual bankruptcies, and then they were all jointly consolidated for administrative purposes, the way Jameson was just discussing. It was filed in September 2025. It's a very large and contentious case because the company's liabilities exceed $11.5 billion, but when it filed, they only had $12 million of cash on hand. And they've also been high profile because the CEO and his brother were both indicted on a variety of fraud charges. Essentially, they were accused of fraudulently obtaining billions of dollars from the company's creditors before driving the companies into bankruptcy. So, a very colorful case. Next slide, please. So among First Brands lenders were a number of factoring companies. And for anyone who's unfamiliar with factoring, it's essentially accounts receivables financing. A company like First Brands might sell its products to customers on generous 30 to 90-day payment terms. And instead of waiting the 30 to 90 days for payment, the company then immediately sells those receivables to a factoring company at a discount. And then, of course, the factoring company makes its profit when the customers pay the receivable in full. In the First Brands case, there were disputes over which creditors had priority in which receivables, and some of the accusations against the CEO and his brother in their criminal cases involved the falsification or inflation of those receivables. So it was a big mess. And all the company's incoming payments of receivables were flowing into an account that had been designated as the factored receivables account, which had grown to more than $106 million. One of First Brands' creditors, a factor called Evolution Credit Partners, asserted a first priority security interest in around $60.5 million of the funds in this account. Next slide. So shortly after the bankruptcy was filed, First Brands filed a motion seeking court permission to spend up to $63 million of the cash in this factored receivables account to fund its ongoing business operations because it was running short of funds. Evolution Credit Partners objected to the motion, arguing that $60 million of the money in the account that more than $60 million in the account was its cash collateral, and that if First Brand spent the whole amount that they were seeking to spend, then the remaining funds, which would be around $43 million, would be insufficient to protect its interests in its cash collateral. Jameson, I think, will be discussing a little bit more about cash collateral in a few minutes, but again, the term essentially refers to any cash or cash equivalent in which the debtor's bankruptcy estate and a third party both have an interest. And in this case, Evolution was that third party claiming an interest in the cash collateral contained in the factor's receivables account. Unless Evolution consented to the debtor's use of that cash collateral, then First Brand's use of the money would require court permission. And of course, Evolution was not consenting to the use of its cash collateral under these circumstances. So in response to Evolution's objection, First Brands argued that Evolution's security interest in the funds was speculative. Due to all the irregularities and fraud that I just mentioned that led to the debtor's bankruptcy, First Brands claimed that its forensic expert had determined that Evolution appeared to have no security interest in any valid invoices. So its interest in the resulting factored receivables account was speculative or limited at best. First Brands also argued that whatever limited interest that Evolution might have in some of the funds in the factored receivables account, that interest would be adequately protected by the remaining $43 million, which was less than Evolution's $60.5 million claim, plus all of the additional pre-petition receivables that were expected to flow into that account going forward. Next slide. So before the bankruptcy court, without ruling on whether Evolution actually held a valid first priority security interest in the funds in the factored receivables account, the bankruptcy court held that whoever held priority in the funds would be adequately protected by the remaining funds and whatever future receivables were expected to flow into the account. So essentially, without ruling on Evolution's security interest, the bankruptcy court was agreeing with First Brands. And based on that finding, the bankruptcy court authorized First Brands to use up to $60 million of the funds in that account. And I think perhaps most troubling for Evolution was the fact that this relief was not granted on an interim basis. There was no approved budget for the debtor to follow. There was no future hearing scheduled to revisit the issue of how quickly the debtor was spending the money in the account or determine how much of the expected future receivables were actually flowing into the account to replace the money that was being spent by the debtor. Next slide. So Evolution acted swiftly and immediately and appealed the bankruptcy court's ruling to the district court, which is where appeals from bankruptcy courts go. It argued that the remaining funds in the account left it undersecured by roughly $20 million. And it also was able to get the appeal expedited because it showed that First Brands was burning through cash and it was likely to deplete the funds without a quick ruling by the district court. Next slide. So one of the basic rights secured creditors have in bankruptcy is that they're entitled to adequate protection of their interests where the debtor is going to retain the use or possession of their collateral during a case. And if a debtor is going to use a creditor's cash collateral without their consent, then the court should impose conditions providing that the creditor has adequate protection of its interest in its cash collateral. On appeal, the district court went out of its way to note that at a hearing on a cash collateral motion, it's not the time or place to make a final determination on the validity or priority of a creditor's lien. If the lien is contested, then a final determination on that issue typically requires an adversary proceeding, which is like a lawsuit within a bankruptcy that allows both sides to file pleadings, to conduct discovery, and to present evidence to support their position. Even though the bankruptcy court did not technically rule on the validity of Evolution's interest in the factoring account, the impact of its final ruling on the debtor's ability to use that cash collateral did have the potential to be very prejudicial to Evolution's interest. And I think that's one of the things that the district court was saying if you read between the lines. The district court held that the bankruptcy court should have conducted only a preliminary hearing on the matter. It should not have made a final determination or issued final relief, and that Evolution only needed to make a prima facie showing of a valid security interest to trigger the requirement of adequate protection. After that, the bankruptcy court should have determined exactly what amount of the funds in the account, if any, were necessary for the debtor to avoid immediate and irreparable harm, which is the standard for being allowed to use cash collateral. And if the bankruptcy court was going to allow the debtor to use any funds in the account, then it needed to also make findings about what funds or what other sources of recovery provided Evolution with adequate protection of its interests. The bankruptcy court had not done any of that, and also by the time of the appeal, the amount of the funds in the account had already dropped below the amount of Evolution's $60 million claim. So the district court then remanded the case back to the bankruptcy court so the parties could litigate the issue of whether or not Evolution did in fact have adequate protection of its interests, and if so, from what funds. Next slide. So very briefly, the case offers three good lessons for lenders. I think the first lesson is don't assume that a first priority security interest in collateral is automatically going to protect you in bankruptcy. You need to be on the lookout for motions that affect your collateral, and if there's a potential issue, then you need to attempt to negotiate with the debtor to protect your rights and object to their motion quickly. Also, adequate protection is a moving target. What might appear to be adequate when a motion is filed or when an order is granted may not remain adequate as the circumstances of the debtor's business change and the case evolves. If a court is going to allow the debtor to use your cash collateral, then consider asking the court to impose interim short duration cash collateral orders with an approved budget for the debtor to follow. And also, finally, disputes over validity and lien priority should be resolved in an adversary proceeding, not at the cash collateral hearing, but a lender still needs to be prepared to make a prima facie showing that its security interest in the collateral may be valid. So its counsel should quickly review all the loan documents and UCC filings and be prepared to object to any motion to use cash collateral quickly. All right, with that, I'll throw it back to Jameson.
Thank you, Norman. Wow, that's an interesting case and very helpful from a creditor's perspective and gives some good takeaways. I guess creditors can rest assured at night knowing that I believe you said the principals ended up being indicted for their actions, so that should help everybody rest easy. Yeah, but thank you. So that's kind of
that.
that's kind of the high level of the case and our kind of example for today, but getting into kind of details of what can be one of the more important first day motions is the cash collateral motion, which is the debtor going before the court asking the ability to use cash equivalents, cash on hand, cash in accounts in order to keep the business alive. And so a common phrase, which is certainly always true in the early days of a Chapter 11 bankruptcy filing, is that cash is king. So what is cash collateral? It is the cash on hand, the cash in the debtor's account that is subject to the creditor's lien. Important to secured creditors because these are the liquid funds that could potentially be, directly applied to the debt that the creditor is owed. But again, this is a bankruptcy. The debtor is going to get an opportunity to reorganize, get an opportunity for a fresh start. And so this has to be balanced with the debtor's needs to use those funds on ongoing operations, funding the business's various expenses. So for example, if a bank has a lien on accounts and proceeds, the bank is then secured by the funds that are in that debtor's accounts. Similarly, liens on inventory and proceeds sold in the ordinary course of the debtor's business will then result in cash collateral, such as, as I mentioned, selling inventory resulting in proceeds. and creditors need to be wary and protect their interests when the debtor is seeking to use that cash collateral. Oftentimes, the first lien holder in these cases will be, a creditor with a lien on all assets, a blanket lien on the assets of the debtor, and they'll be in first position. And there can potentially, depending on the amount of debt owed, there can be multiple lien holders interested in cash collateral, depending on how much cash collateral there is and how much the debtor is seeking the court to allow the debtor to spend. This is all governed by Section 363 of the Bankruptcy Code, which prohibits a debtor from using cash collateral without one of two things being satisfied. Either the creditor negotiating, coming to an agreement, and coming to consent on the debtor's use of that cash collateral, or the court forcing it down the creditor's throat, the court authorizing the debtor's use of that cash collateral. In short, this means that using cash collateral can be done by agreement through the creditor, through the debtor negotiations, or a hearing is going to be held on the debtor's motion, on the creditor's objection, and the court will authorize the debtor's use pursuant to a budget that it provides. But the key consideration when the court authorizes it over a creditor's objection, and like we discussed in the first brand's case, is there must be adequate protection. So what is adequate protection? Well, despite a laundry list of defined terms in the Bankruptcy Code, and I'm sure when I asked what it was, you all flipped to that section of the Bankruptcy Code to get ahead of me and figure out what that definition is. But I'm sure you also have not found it. It is not defined in the Bankruptcy Code. But that's not a bad thing. It creates creativity from the creditor's side, creates flexibility in what will truly make a creditor adequately protected. And the goal of adequate protection is to maintain the status quo. It's to keep the creditor in the same position it otherwise would have been while the debtor is using its cash collateral. Similar to the example, the first brand's case, we talked about, what the lien was 60 million. I think it was authorized use of 40 million, or the adequate protection was 40 million. So there's a gap there of 20 million. Is that maintaining the status quo? I believe the other consideration was, accounts receivable, which how long are they outstanding? Are they collectible at all? Is that adequate protection? And these are concerns that need to be raised to the court. These are concerns that need to be taken up with the debtor on testimony at the hearing. But the bottom line is the bankruptcy must ensure that the creditor will not be harmed by the debtor's use of cash collateral, balancing the debtor's ability to reorganize. We can hit the next slide here, Haley. So what does cash collateral look like from a practical standpoint? The debtor's got to propose a budget for spending the creditor's cash collateral. The creditor reviews it and makes a determination of whether it's an acceptable budget, listing, projected income, projected revenue, and then projected expenses. And this is all going to be based on historical data, but also some of the fact cutting that debtors go through when they file a bankruptcy case. If a budget is agreed to, then it's done without a hearing. This can often be done, and one of the concerns I heard in the first brand case was that it was just on a final basis, just like that. From a creditor's perspective, that's a little concerning. We're going to want, especially if there are concerns and not consent, we're going to want interim orders so that we can come back and revisit it. If not by consent, the hearing will be held, and you have the ability to attend the hearing and ask the debtor questions under testimony to provide insight into the proposed budget. Creditors should go through and scrutinize that budget line item by line item, which can be tricky as a practical matter because oftentimes, especially with these first day motions, you get a petition, maybe you didn't know it was coming. These motions are filed in conjunction with that petition. It's all being rushed. Oftentimes when I appear for cash collateral hearings, if we haven't come to consent, I'm getting that budget a couple minutes before the hearing starts. And so you've got to be acting on your toes, quickly reviewing, scrutinizing that budget, each line item, and making sure you know how the debtor is proposing to use cash collateral. So the key takeaways are to scrutinize that budget, make sure that there's adequate protection, which can be in the form of payments, financial reports, getting interim orders, making sure there's clear default provisions in that order of authorizing cash collateral and knowing what triggers those. And then finally, what kind of notice, kind of like we discussed earlier, what notice is required in order to get an emergency hearing on it. And so the fundamental tension, like we've gone over during the course of today, is balancing both the secured creditors' rights and protecting them as well as the debtor's need and want for a fresh start under the bankruptcy case. And I think all these ideas are tied into what we learned with the First Brands case, which is another real world example, but an extreme example of what efforts creditors can take in the bankruptcy case, and then if some unfortunate result happens, taking it to appeal to the district court on a quick basis as well. Let's see. So moving into an example, if we could hit the next slide, Haley. And sorry, I guess I forgot to ask you to hit a slide, so we'll hit one more. So high level here, we're running short on time, so I'm gonna kind of go very high level. But this is kind of a proposed budget we threw out there and kind of looking at it. The idea here is, first day motions, the debtor's proposing this budget in order to maintain its ongoing business operations. And, we're at a first day hearing on cash collateral motion. There's no consent. Creditor has objected to the use of it. And so what are kind of the line items that we're going to be looking at that are problematic, that we want to raise to the court's concern, that we want to get testimony on from the debtor's principal, and we want to nail down and cut more of that fat to preserve the secured position of the creditor. So as you can see here, the biggest one, the primary concern is, well, I'll start from the top, the 13-week total. So at the outset of a case, if a debtor's seeking, 13 weeks of spending, my gut reaction is, without knowing more about the case, let's do this on an interim basis. Let's do 1 month, and potentially have required production of financials halfway through the month so we can see how the debtor's actually performing as compared to what they proposed. Another big issue with this budget laid out is that bottom line miscellaneous. What is that? We would, certainly ask the principal on examination to, separate out those line items and discuss, what they are actually proposing, and what could be caught up in that category. And so that's certainly an item we'd want to hone in on, and frankly, walking through each line item, we would want to make sure the rent is reasonable, make sure it's based on, historical figures that are accurate, make sure insurance is being paid. That's another method of adequate protection that's important. If to the extent that, there's, a lien on vehicles, we want to make sure that those vehicles are insured. So there are a lot of forms that creditors can protect themselves and make sure that everything's being followed. Next slide, Haley. And I'm not going to go through all of this since we're running short on time, but the other side of the coin of cash collateral is DIP financing. So at a very high level, it's essentially new lending after the bankruptcy is filed in order for the debtor to maintain its ongoing operations. Again, this requires court approval, and it can include different aspects of super priority claims as well as priming liens. These can be lent on, there are 4 main statutory frameworks. This can be unsecured credit, ordinary course, in which case you don't need court approval. Then we fall into where the motions are required and seeking court authority, where if it's outside unsecured credit, outside the ordinary course of the debtor's business, we'll have to have a hearing and see how creditors' rights are affected. And then the more important ones and the real issues come up when, the debtor's proposing to subordinate liens in order for this new financing to get in place. Oftentimes a way around this is, where a secured lender that's already in first position can come to an agreement to make more financing to the debtor. And we can go to the next slide. And so those are kind of the high level key considerations of the DIP financing order and what we want to think about. Listed here on the PowerPoint are some of the provisions you'll want to make sure are provided for in the order approving it, such as making sure that, you know, there are milestones in the case. So when the debtor doesn't need more financing, you know, that is limited and there's a cap to it. Amount and terms, interest rates, things of that nature all want to be closely monitored, especially when, you know, there's a subordination or a prime lien that's going to take effect. And we can hit the next slide. And so high level, that's kind of the considerations of cash collateral DIP financing, kind of the differences, the similarities. But the key consideration, it's all under chapter or section 363 is where it's governed in the bankruptcy code. And the other key consideration is that the debtor has to seek court authority in order to spend it or acquire that post-petition financing. Next slide. And Norm, I'll pass it back to you if you want to wrap us up here.
Yeah, thanks, Jameson. Okay, so we're over time, so we'll just wrap it up, and of course, we'll stick around for a few minutes if anyone has any questions they'd like to submit. But the key takeaways are speed is critical. If you fail to object to a motion that could be prejudicial to your interest, then you risk being bound by unfavorable orders. Adequate protection is your primary lever. Demand it in your objections and insist on meaningful protection. And adequate protection is a moving target, as we saw in the First Brands case. By the time they got to the district court, those funds had already been paid down, or that account had already been paid down, and they were already undersecured, underprotected. And lastly, you definitely want to scrutinize any DIP financing proposals to make sure that the terms are appropriate. They're not going to adversely affect your lien priority, and object if the terms are overreaching. And I think that just to drive the point home, the real happy ending in the First Brands case, I read an article this morning that the court actually on remand ordered First Brands to return over $25 million to the accounts receivable, or the factoring account in question. You know, whether or not the debtor will ultimately be able to do that is a different question. But the quick action by Evolution Credit Partners did pay off in the end, and they did protect their interest through quick action. So Haley, and just real quick, just in case, well, Haley, are there any questions for us in the chat? As they
Hey
say?
everyone, I do not see any questions. So we'll go ahead and wrap up, but that doesn't mean that no one's welcome to email us to ask us anything.
Yeah, and on behalf of both myself and Jameson and Haley, thank you all very much for attending today. We like putting these programs on each summer, and we hope they're helpful. And we look forward to seeing all of you individually as we represent you in cases going forward.
Yes. Thanks so much, Norman. I'm going to wrap up, and you guys will get this slide deck as well as a link to our recording tomorrow. And stay tuned for our final installment on August 19th, and that is going to be with Michael Weaver and one of our South Carolina attorneys, as well as Thomas Wolf in Raleigh. So thank you guys so much. That is going to conclude today's webinar. Thanks.